10 minutes, so I think I should wrap it up by 6:20. I won't hold you beyond that. I'm first of all grateful to the Honorable Chief Justice of the Delhi High Court for presiding over this occasion. It means a lot to us. I'm also grateful to the organizing judges on the bench and the dignitaries of the dais. Let me start with something which is perhaps offbeat. I think those who practice in the Delhi High Court are extremely blessed. And this is not a statement of platitude, but it's a recognition and acknowledgement of the opportunity that we get here. Second, within that High Court, to practice on the commercial side is a privilege. And within the commercial side, to practice on the IP side is a greater privilege. Allow me to use the word pampered in a non-derogatory sense. I think we are pampered. I don't think there's any other court or any other side of this honorable court which bestows this field of law with such opportunities and attention. And therefore, I believe that we have enhanced responsibility to operate with integrity, honesty, and acute knowledge of the fact that we are spoiled compared to every other court that I've had the opportunity to appear before, either in terms of choice, talent, options, opportunity. And that, I think, should inform the way we present our case either in writing or in our oral submissions. I don't think brevity is a virtue. In a crowded system which is almost broken, brevity is a necessity. People constantly think that the United States is perhaps the most litigious country. My apologies for saying so. Even if 10% of India decides to go to court, the system will break. And therefore, when you look at people waiting for bail applications, matrimonial disputes, honestly, I can understand when some judges feel that this is luxury litigation. I understand where they're coming from. When you look at that and this, I think we have the best of services being offered from the registry to everything else. And if you wish to infuse that spirit of recognition in the way you present, here's how I would go about it. I come from the generation that has learned the hard way the errors that drafting or poor drafting can lead to by appearing before Justice Valmiki Mehta, Justice Muralidhar, Justice Ravindra Bhatt, and Justice Enlaw. I've burnt my fingers on multiple occasions, and I actually managed to maintain a mistakes log of all the mistakes that I made, and I continue to make. This a separate mistakes log of it. I hope someday it gets published after I'm done, but not before that. Mistakes which I'm aware of, which nobody else was aware of. I have 3 or 4 suggestions to make, and I hope I wrap it up by 6:20. Please consider these suggestions. And at the end of it, I'll come with a request to the bench, so to speak. 1, if a written submission post-arguments can be completed in 5 pages, how much longer should a plaint or a written statement be? What is the thumb rule? 3 times, 4 times, 5 times, 10 times, what is it? 3 would be a good number, or 5 would be a good number. So it should be possible for us, by an order of magnitude, to complete our pleadings within 5 times of the written submission at the very least. That should be a decent thumb rule to go with. So let's reverse engineer this. Don't start drafting the plaint or the pleading. Start by, first of all, putting together a map of the points that you wish to present. And if you had to present this in the form of a written submission, how would it translate to, or what would it translate to? And then if you had to expand each of those heads or elaborate upon each of those heads, how much would you actually need to speak of? Which is, if the written statement is the juice or the essence or the saransh, how much of pulp and fluff do you actually need to pack it with? And to put it in the parlance of pharmaceutical patent litigation, if the written statement is the active pharmaceutical ingredient, how much of excipients do you need around it for that pill to be consumed by the bench? Maybe this is one decent thumb rule to consider when you draft. Second, regardless of whether someone wants to be a counsel or not in terms of being the one who ventilates the matter or canvasses the matter before the court, I think one thing that has helped me in my formative years under Mr. Sai Krishna is I would read the draft out aloud to see if it has an evocative impact. Which is, if a question is put to me on where is this said in the draft, by the time I'm done reading that particular paragraph of the draft, the punch should have landed. Which means there is no need to support, buttress, or countenance that argument beyond reading that particular paragraph. Therefore, that should help. What this means is, invest in drafting and enjoy the process. Enjoy the process of drafting, because at least for the better part of your formative years, you're going to be drafting. So invest in that. And as someone who is certainly not a Luddite when it comes to technology, I'm not anti-technology, I would certainly exhort you to not use AI to draft. Please don't. You can use AI perhaps as an enhanced tool of research, but to treat this as a substitute for your own mind or brain for the purposes of drafting, I'm sorry to say, in the long run, you're going to stunt yourself in terms of the value addition that you give yourself in terms of sheer skill sets by using AI for the purposes of drafting. Please don't. 3, there is a tendency, at least on the IP side, to see IP suits as glorified interim injunction applications, where the plaint itself is a glorified interim injunction application, and the interim injunction application is a replication of the plaint, and the affidavit is a replication of the plaint. That needs to go, because we may be a specialist subject, but we are not exceptions to CPC and evidence. And therefore, as much as we may want to think that we are exceptions to certain rules, we are not. And I think the purpose of this entire workshop is to show that Order 6 of the CPC continues to apply to IP suits, no matter how hyper-specialized the area of practice may be. 3, therefore, prepare for the long haul under the assumption that this matter goes to trial, because even if your intention is to bring the party to the negotiating table after the 2020 stage, which is the interim injunction stage, it may go to a test match. And if you're not ready for it, you've had it. 3, on the question of suppression, on the question of misrepresentation, please do bear in mind, even if the suppression is by a party, you as counsels will pay the price for it with loss of reputation and goodwill before the court. And I operate with that acute sense of responsibility only for one good reason, and I'm happy to confess here, I've already confessed this before Justice Gedel in one of my hearings. One of my very first patent suits that I drafted myself was CSOS 1989 of 2010, which was 10XE Incorporation versus Moby Antenna. And then the second suit was a twin suit, 1993 of 2010, 10XE Incorporation versus Andrew LLC, which now has become CCI versus Moby and CCI versus Andrew, in which Justice Jyoti Singh has passed an order of $217 million of damages in the where of course the Chinese party has effectively vanished. No surprises there. But the point is, in that suit, we managed to secure an interim injunction, an ad interim injunction. Mr. Kaur was leading us. The mistake I made was, the patent specification that the client had sent me, I trusted that document and I filed it as the actual patent that was granted. Turns out that there were a few modifications in the specification. They were not material in terms of the amendments, but clearly that was not the one that was granted. My opposing counsel was Ms. Gayatri Roy from Luthra, then Luthra as it existed then. She served us with a 39-4 and a 340 as it existed then. My first feeling was my soul was shattered, my confidence was broken to smithereens. I just sat in the chamber in High Court and my head was reeling, because my first question was, how was I going to face Mr. Sai Krishna? Not for any other reason, he wouldn't become the Hulk. But the point is, I had let him down because this was my very first patent matter, and as a 23-year-old, he had given me the opportunity to preside over it. He said, go ahead and do it. And that mistake is the star mistake in my mistakes log. And with that sense of soul-shattering fear I've always operated, that even if this was never intentional, why should the other party give you the benefit of the doubt, and why should the court give you the benefit of the doubt? Just 2 more minutes, I won't take more than that. So operate with that sense of fear because it's important, because your reputation is not your virtue, it is your sword and your shield in your profession. That is what will save you ultimately. Your integrity as a counsel and a lawyer will go a long way, contrary to popular perception about this profession. 3, I believe that people in this profession are like drivers on a road, which means each of us will be driven by self-interest. And if you're bound to be driven by self-interest, it is the traffic signal or the cop standing there who will ultimately herd us in a particular direction. And if there is a country where self-regulation rarely works, I think it's Bharat. My apologies for saying so. And therefore, the better thing to do perhaps is also to hope that certain levers of change in terms of attitudinal change and behavioral change and integrity change can come by, let's say, certain enabling and empowering provisions which exist in the act or in the legislation, so to speak. The better part of our IP legislations, at least trademarks, copyrights, and designs, don't need to go to trial, because I don't honestly understand what is the earth-shattering difference between the trial stage and the 2020 stage between these matters. When it's ultimately a question of the law, it's a question of a standard, it's a question of legal fiction being applied. And perhaps the lowest common denominator, which is the average person's imperfect recollection, so on and so forth. If that is the case, ever since the introduction of the Delhi High Court IPD rules of 2022, I don't believe Rule 27 has been invoked enough and often, which empowers the court to deliver summary judgments in matters where they deem fit without the matter having to go through the entire pipeline of trial. Why is this important, and how does this relate to the issue in question or the theme of the day? Summary judgments will test your pleadings and your documents. They will push you, which means you don't get to make up for flawed, inadequate, faulty pleadings through your evidence affidavits, and as Mr. Mehta rightly pointed out, I think someone else, that you hope that the counsel will save you at the end of the day. That's too much burden to put, and that's a huge gamble. So therefore, perhaps if an example can be made out of pressing into the service or invoking Rule 27 as often as possible in these straightforward cases, relatively speaking, compared to patent matters, perhaps you could effect a different kind of change. 3, I can only hope that we make sure that these opportunities that have been bestowed upon us, we use it to the best of our abilities. Because sometimes I say that, allow me to be a bit candid here, when the roster is populated by fresh faces, I say, please, let's put our best foot forward, because we need to ensure that this good run continues in terms of people who are interested in taking up these matters. And if ultimately we develop a reputation for pleadings which are not up to the mark, or which believe that they're exceptions to the norm in terms of CPC or IPC, it shows the rest of the bar in poor light. And most importantly, as IP practitioners from the Delhi High Court, please try visiting any other High Court, and you'll realize that you're taken very, very seriously. The judgments of this court are practically almost equal to the Supreme Court as far as perception goes. 3, I believe that the moment you say Delhi High Court IP judgment, there almost ends the discussion. And if that sense of prestige and that sense of responsibility must continue, I genuinely believe that we have a lot to do on this front. I just have one request, perhaps I'll use this opportunity. This is not slide, one humble request. Not only should we be known for interim injunctions or judgments on interim injunctions, I think it's time that we also become known for final judgments. So could perhaps one day of the week or 2 days of the month be allocated to regular hearings, so that we finally get to see how they operate in post the 2020 stage. Thank you.